Thank you, Cathaoirleach. And with, I suppose, the approval of the House, I'm probably going to give a lengthy response, but if that's okay, because I do want to respond.
How long?
Okay, I won't be that long.
I hope you won't take on.
I won't take that long, I promise. No, look, I appreciate there's been a lot of contributions, not just in today's debate, but obviously last week as well. And I do appreciate the views that have been shared. I recognise that these views are complex, that they are varied, that there are differing views and opinions here. But maybe what I will do is set out at the outset just some clear facts and then try and respond to a lot of the comments and the questions and the statements that have been made over the last week. Firstly, what we are proposing here is not radical. This is not new. This is the norm in many EU member states. What we're introducing is new legislation for hate crime, but we already have legislation around hate speech. So it's important to stress at the outset that this is not new, this is not radical. Hate speech and hate crime exists in our society, and I think there's very few people that would reject that statement, although I know there would be some that do. Many senators have mentioned that this has been rushed, that this is legislation that has potentially come from nowhere, that there hasn't been time allowed for debate. I think this is long overdue legislation. It has been in development for 4 years. That's since the initial consultation back in 2019. The general scheme was approved by government in April 2021, so over 2 years ago. It was then another year before pre-legislative scrutiny was concluded last April, and after a period of what was intense drafting, a bill was published in October and then spent 6 months passing through the House. So this has not been rushed, far from it. I cannot stress that enough. There has been ample time for discussion, debate, engagement, consultation. It hasn't been rushed, and I can commit to colleagues here, this won't be rushed again. I'm not going to rush this through the Houses. While hate crime offences are new, again, I would remind senators that hate speech offences are not new, despite a country or a narrative to the contrary that continues to dominate a lot of what I'm seeing. Hate speech is currently an offence under Section 2 of the Prohibition of Incitement to Hatred Act 1989. That is the law that is here right now, one that we must all adhere to. Yes, I have yet to hear anyone disagree that the 1989 Act doesn't need to be updated, and that's simply what we are doing here. And much of actually what is being discussed and many of the comments and the issues that senators have, it's already actually in legislation, and we don't have this onslaught or landslide of people being prosecuted or put in prison. Again, far from it. I'll use my time now just to specifically address points made by senators. A number raised concerns around what they see as a possible chilling effect, and I know, Senator Chambers, you raised that last week, as have many others. As I have, I suppose, tried to explain or been at pains to stress, people can continue to say what they want, but not if it incites hatred and not if it incites violence against others. People can still say awful things to each other, and I was asked why I'm saying about offending. You know, this has been raised. People can still offend other people. That's happening now, irrespective of whether this legislation is in place. People are not being put in prison. They're not being prosecuted. People will continue to say horrible and hateful things, whether this legislation is in place. It's not the intention that we stifle debate. It's not the intention that we shut down criticism. There are very clear and very explicit safeguards in this legislation to make sure that we protect freedom of expression, that there are robust defences that people can avail of too. And, you know, in line with the Constitution, an explicit protection is contained that you can discuss a protected characteristic, that you can criticise a protected characteristics, and then you have very clear defences for what you've outlined, Senator Byrne, for reasonable, genuine contributions, whether it's in literary form, artistic, political, scientific, academic discourse. There's religion, obviously, is a protected characteristic, and that was mentioned in the article that both senators outlined. But not just that. This is not just about an individual member of An Garda Síochána deciding to press charges. There has to be clear evidence of what the intent was here. There has to be a decision by the DPP that that evidence is there. There then has to be a jury of peers that decide beyond reasonable doubt. So I cannot stress enough that this is not the case that somebody is going to say something, not mean it, and suddenly find themselves prosecuted, or that they would say something that they genuinely believe that a lot of people disagree with them on, and that they're suddenly going to find themselves prosecuted. And that is very clear in this legislation, I believe, because we have an explicit protection contained around freedom of speech, the ability to discuss and to criticise protected characteristics, the defences that are there for all of the reasons that I've outlined. This is in line with Section 10 of the European Convention on Human Rights, which provides that a communication will not be taken to incite violence or hatred solely on the basis that it contains information or ideas that offend, that shock or disturb. People have still an absolute right, as I've said, to say offensive things. Free speech will remain a cornerstone of our democracy, and this is enshrined in Article 40.6.1 of our Constitution. However, and I think many senators have pointed out, this is not an absolute. Nobody has the right to incite hatred or violence against others through their actions, through their words, on account of their hatred of that person's identity. And to paraphrase Senator Ward's remarks, this bill is actually not about stifling debate, it's about taking hatred out of the debate. And there is a lot of hatred in discussion and content and engagement online or indeed outside the online space. To address other queries, Senator Mullen, as mentioned, one of the primary aims of this bill is to simplify hate speech and incitement offences from the 1989 Act. That is why the broadly understood legal term of incite has replaced stir up. So we're not confusing languages or saying one piece is not connected to the other. This was agreed upon that it's a more appropriate use of modern legislation, although the meanings are exactly the same. So to stir up or to incite is the language that is used more appropriately in this day and age. Senators should also be aware that they and everyone else in the state will be able to retain the freedom to offend whomever they want, even in the discussion of protected characteristics, as long as, again, they don't cross a clear line into incitement to violence or hatred. It's only the extreme forms of speech that deliberately and recklessly incite acts of hostility or violence and cause harm to persons with a protected characteristic that will be criminalised. And just to maybe mention some of the points that were made in the last speech, Senator Mullins, I think, said that a comment, men can't breastfeed. That's not hate speech. That's not what we're talking about here. That's a statement that might be somebody's belief, but that's not a person setting out to incite violence or hatred against, whether it's men or women or transgender people.
Minister, could I just stop you 1 second, if you don't mind, please, just to welcome the Cushla Active Group from Roscommon and Athlone. You're very welcome to the public gallery today. Thank you. Sorry, Minister.
You're welcome. Secondly, J.K. Rowling, and was again mentioned this afternoon. I have read her commentary. I have seen a lot of what she has said. And again, she would not be prosecuted under this legislation. Identities described in this House as nonsense. A person's ability to identify in whatever way they so wish. That's not hate speech. I mightn't like what is said in that way, and many others mightn't, but it's not hate speech. So, there are many examples that have been given in this House, and I'm saying very clearly that is not what we're talking about here. It might not be a statement that people like to hear, or certain people like to hear, but that doesn't mean that it's hate speech. None of the examples referenced in this debate, although, as I said, others might not like them, would not be criminalised unless the individuals can be proven to have directly incited violence or hatred on the basis of that protected characteristic. The culture wars that are being discussed here, they're happening anyway. They're happening online. There are horrendous things being said, and that is in the absence of hate crime legislation and with hate speech legislation, which we're trying to improve. This is not the way that we have done things in this country. I think when it comes to the division that's been sown in this culture war, we have dealt with really difficult and really serious issues and emotive issues in a very calm, in a very respectful and a very evidence-based manner. And, we can point to recent referendum that we've had, be it on the 8th Amendment or be it on marriage equality. While there have been different voices, different points of opinion where people might disagree and not like what has been said, that will continue, and that type of discourse and debate will continue under this legislation. The law isn't about cancelling people for their opinions. In a modern, liberal democracy, this is about our responsibility as legislators to protect victims of hate speech and hate crime from harm. And I said this at the weekend because I think we really need to remove ourselves from a lot of the noise and the commentary and the hateful commentary that's happening and the culture wars that are happening, and bring it back to what are we actually trying to do here. We're trying to protect those who are most vulnerable in our society, who we know are more likely to be victims of hate speech and hate crime. Senator Flynn emphasised the need for enactment of this bill within your own community, and I was struck by your reference to Pavy Point's finding that only 5 prosecutions have been successful against instances of inciting hatred against members of the travelling community in over 30 years of the existing legislation. And if we think of that community, the protected characteristics that have been expanded on now, most of the new characteristics were not part of the 89 Act. So the fact that there have been so few where you actually have protected characteristics like the traveller community, I think shows exactly why this is needed. A number of senators, and this is probably one of the biggest points I think that has been raised, has said that there is a need to define the terms of hate or hatred for the purposes of this bill. I have been advised by 2 Attorney Generals, not just the current but the former Attorney General, against adding synonyms for hatred to the statute book. So firstly, in the 1989 Act, hate is not defined. In many other criminal offences, hate is not defined. So I don't see or hear any senator here saying that it has not worked as part of the 89 Act. That's examples where I can give senators of murder cases where hate is used as part of the prosecution or defence. There's no request or need for the word hate to be defined because it is commonly understood by the judge, by the jury, by the DPP, by those who are prosecuting and defending. If you take, though, other jurisdictions where different words are used, so in England, Wales, Northern Ireland, the term used is hostility, but that's not defined. People have an understanding of what hostility is. They don't define that. I personally would think, and I think legally, hostile or hostility is actually a lower bar than hatred. If you look at Scotland, the words ill will or malice are used. Again, they're not defined, and I would see ill will as certainly being a lower bar than hatred in this instance. The EU framework doesn't define hate either. One colleague suggested that we would use the word intense opprobrium or disgust to define hatred for the purpose of this bill. And I have to ask, are we really saying that a more commonly understood concept to the average person on the street or even in this house than hatred, or indeed to an average person sitting in a jury, would attach the concept hate or hatred? Would that actually provide much more clarity? Excuse me. Would using those words actually provide more clarity, or would they actually make the legislation inoperable? What about bias, prejudice, contempt, hostility, bigotry, which have all been words that have been suggested, and I'm not saying there's anything wrong, but do any of these actually clarify the meaning of hatred, or do they actually serve to obstruct it? Do we then have to clarify what those words mean? In a practical sense, the term bias and prejudice here are inappropriate as they create too low a threshold. Everyone holds some form of bias. It is an unfortunate part of the human condition. Some of these biases are likely unconscious. It would be inappropriate and unfair to set out that a bias or a prejudice that's held by a person when they're committing an offence could necessarily be enough to label it as a hate crime. From a legal perspective, the Attorney General has cautioned about the risk of successful legal challenge to prosecutions brought if other words or synonyms are attached to a definition of hate or hatred. Defining either word too narrowly could lead to loopholes and ways of evading prosecution. It would also place an almost impossible burden on the prosecution, whereby each one of the proposed terms would then have to be proven beyond reasonable doubt. So, for example, for a hate element to be considered as a component part of a crime, you would have to show bias, and you would have to show prejudice and contempt and hostility and bigotry if hatred was defined in reference to these words. So there's actually a greater burden and less clarity if we were to move in this direction. How is this preferable? I would say to remaining consistent with what is already on the statute book, with what is routinely used in court proceedings. Senator Joe O'Reilly, I think, is correct in what he said to reference the Interpretation Act, that the ordinary meaning of the word to reasonable people is clear and nobody is in any doubt as to what hate means. Senator Chambers again was concerned that recklessness with respect to the incitement offences lowers the threshold too far. However, if you look at the existing law, it criminalises material that is intended or likely to stir up hatred. Recklessness is not significantly different to likely to. It means knowing that there was a risk and proceeding anyway. So it is simply, again, a change in language to update it as to what is appropriate and what is generally used now. It's important to note that incorporation of a test of recklessness was widely welcomed, I think, by many of the submissions made during the pre-legislative scrutiny. The test for recklessness, it is something that is well established if you look at the Non-Fatal Offences Against the Person Act of 1997 or other legislation when it comes to criminal law. Our legal advice confirms that including intent or recklessness is legally permissible and it is appropriate. Several senators drew attention to the campaign of disinformation that has accompanied this legislation, and it has included misleading claims by certain commentators and on social media that the public consultation outcomes have been ignored. And it's been said to me time and time again, this is not true. It doesn't reflect the deep engagement that my department has had with key stakeholders. And as I outlined in my opening remarks, the public consultation was intentionally wide. It was intentionally wide in scope. It included 5 different strands to try and seek views on the new legislation to deal with both hate speech and hate crime and how it should actually be developed. Giving voices to those most affected by hate speech and hate crime was hugely a vital part of this process. Despite some online criticism and commentary being amplified disproportionately, there has been overwhelming, significant support for the inclusive and victim-centred legislation. 4 of the 5 strands of the consultation that we had received significantly positive feedback. The 5th, which is the one that keeps being pointed to, was an online poll where people could actively or had to actively select to take part in it, and what it actually claimed was that hate speech doesn't exist, it doesn't happen, it's not true, we don't need it. So we can interpret things how we want to, but I want to be very clear, the consultation that we had, 4 of the 5 strands were overwhelmingly positive. The 5th, which was online, where people actively took part in it themselves, claimed in a very high percentage that hate speech didn't exist and that this legislation wasn't needed. So I think there's a big difference between what is being said, that the majority of people who took part in our consultation don't want this and it's not needed, because that's simply not what happened. New research conducted by the University of Limerick and Queen's University Belfast included an Amoric research survey, and I think this survey is more representative of the general population, which shows that over 2/3 of those polled are in favour of hate crime legislation. Furthermore, the research highlights the general public's understanding of the need to protect certain groups of people from hate crimes, with 82% of those polled favouring the protection of transgender people in hate crime legislation. Just to respond maybe quickly to a few other concerns raised, Senator Clifford Lee mentioned that anti-Semitism is not covered under this bill. Members of the Jewish community in Ireland, practising or not, I want to reassure her, are protected on the basis of the protected characteristics of either dissent or religion, and in prohibiting the denial, condonation or gross trivialisation of the Holocaust under Section 8 of the bill. Dissent specifically applies in the case where you have secular or non-practising Jews mentioned by the Senator, and this was a very deliberate addition to the bill's protected grounds last year, and it aligns with the European Council framework decision on combating racism and xenophobia. The definitions used in relation to genocide denial are to ensure that Ireland's international commitments in relation to the Holocaust remembrance are also met. Some senators have taken issue with the meaning of gender for the purpose of this bill. And again, I think unfortunately so much of this debate has focused around the protected characteristic and gender. I think maybe just to take a step back, where obviously this is Pride Month, I met with quite a large group of representatives from the LGBT community last night with the Taoiseach and other colleagues. And while it was a very positive meeting, what they are very clear is not just that this legislation is necessary, but that it is very much needed now. So while we have made progress, be it arranged marriage equality, be it even in yesterday the progression of a new scheme to disregard criminal convictions for consensual sex of men, or whether it's around banning conversion therapies, there is still a significant number of the population of the LGBT community who feel that it is less safe for them now, and that they are more discriminated against now than they were 10 or 15 years ago. So when we talk about gender, when we talk about sexual orientation, when we talk about gender identity, and speaking to those groups and representative groups, they are very clear that this bill must encompass and must represent their entire community, and that it's not just wanted, but that it is very much needed at the moment. I mentioned at the outset of this debate...
Welcome members of the LGBT Ireland group who are in the gallery as well today, so just to welcome the forum as well. Thank you.
And to thank them, and obviously to acknowledge the work that they have done in contributing and taking part in the overall consultation of this. As I said, as I mentioned at the outset of this debate, that it is common legislative practice to have different meanings in terms in different acts specific to the purpose of the legislation in question. And again, this is referring to gender for the purpose of this bill. The bill provides that for the purpose of this legislation, gender means the gender of a person or the gender which a person expresses as the preferred gender, or with which the persons identify, and includes transgender and genders other than those of male and female. This is to allow for the protection of transgender and non-binary persons based on recommendations from civil society organisations, and is in line with international good practice. So, for example, if a person who identifies as non-binary leaves an LGBT Q+ venue. They're then subjected to a homophobic attack. The intention is that they should also benefit from this legislation, and without the interpretation that we have set out, they would not, and that was highlighted to us, and that is the reason for the definition. To define gender in the same way as the Gender Recognition Act would mean that this person would not be protected. This definition and the suggestion that we're now changing other legislation only applies within this legislation and would have no bearing outside of it. So this is for the purpose of this legislation and what we are intending to do here, and that is to protect people from hate speech and hate crimes. It does not change the Gender Recognition Act, any definition there, or in any other piece of legislation. Maybe just to touch on other points that have been made by colleagues again today, in particular around the reverse burden of proof. Firstly, again, this is very much part of the 89 legislation. So this is not changing anything, it's not introducing anything new. It is a concept in criminal cases. Again, it has to be proven that there was an intent to incite hatred. And I gave the example over the weekend where someone is stopped on their way to a protest. They have significant amounts of literature, and on that literature there's very clear language which would incite violence or hatred against a group of people. You know, if a person was caught with a bag full of drugs, the assumption is that they are trying to distribute or going to distribute them. The assumption would be here that the intention is to distribute this literature unless somebody can prove otherwise. That's not new. It's a concept in criminal law. It's already in the 89 Act. We're not changing it. So I just want to be clear, I don't think any senators are trying to change how that applies in other criminal instances. This is not new, it already applies here. Secondly, in relation to the Gardaí, this Garda power already exists in law. We're not changing it. What we're simply doing is modernising it to make sure that it can take into account the changes in technology, the ways in which people communicate, which wouldn't have been applicable back in 1989. Senator Cockrell asked if we would be pausing the bill. My intention is not to pause the bill. I think it's important that we progress through the stages, that we allow for debate and discussion. As I've said, I will engage with colleagues the entire way throughout, but I don't see any purpose or reason to pause it when we have spent 4 years discussing and debating and actually getting it to the point that we're at now. In relation to language and the Irish language being a protected characteristic, the way in which we identified the protected characteristics, it was through public consultation, expert engagement, looking at the facts that we have where people are most likely to be discriminated against, data from the Gardaí. That is where we came up with the protected characteristics, but specifically for Irish language that would be covered under nationality or national or ethnic origin, descent or race. So it is actually covered and would be covered under those areas. In relation to Senator Clonan's, and he's not here, and I suppose what I would like to say is I'm very sorry for what happened to him at the time, but that happened 25 years ago despite this legislation. This was not about prosecuting him, this was about people who did not like what he had to say and tried to shout down and tried to prevent him from saying what he had to say. This bill will not prevent somebody like Senator Cloonan saying what he has to say. It actually protects the It will not criminalise provocation or provocative opinions. It will set out very clear grounds for reasonable and genuine debate, and that's section 7.3 in the bill. So what happened shouldn't have happened, but this legislation does not change the fact that people will continue to shout down and to try and stop other people from having opinions. This legislation would not criminalise the senator for what he was saying. In fact, it's actually protected in what we're saying here, that if you're an academic, if you are saying things for academic debate, discussion, be it in an artistic way, political way, that you're actually protected in this legislation. So I think this point, people keep saying that this is happening to me now, and I'm afraid with this legislation that I won't be able to say what I'm saying. People are already being attacked and, verbally abused, be it online or elsewhere, irrespective of this legislation. What we're talking about here, and I bring it back to the fact that there are a minority of people who are being verbally targeted, that we're trying to protect here, who are being physically targeted, and they're the people we're trying to protect here, not people who are making contributions to political or academic debate. That's very clear in this legislation. If you go through every single part of the bill, it very clearly sets that out. Again, and I think that is in line with what you have said yourself, Senator Byrne, but I would say the law is not absolute. So you said yourself, it depends on the individual circumstance, the evidence, the context in which something has been said. If you look at any other type of crime, we don't set out absolutely every single possible outcome, because we can't We can't set out every possible outcome here. We don't know what might happen. We have to allow a judge and a jury and a group of our peers to decide what are the circumstances and how we apply them. So we can, insofar as possible, set out the parameters here, set out the very clear guidelines, the rules, what are the protections, what are the defences, but we do need to ensure that there is an ability for a judge and a jury to take all of the circumstances into account and to obviously make a decision as to what the outcome should be. So I think I've addressed all of the points that have been raised. I appreciate there are different views on this, but I would ask senators, particularly when you're receiving a lot of information or a lot of emails on this. I too have received a lot of emails. I've had a lot of commentary online and otherwise. And while there are people who have genuine concerns that their freedom of expression will be prohibited, a lot of what I'm seeing is actually what we're trying to prevent here. A lot of it is very targeted. A lot of it for people who maybe aren't strong and aren't able to deal with some of the targeted abuse and online hatred. We need to make sure that there are protections in place to support them, and that is exactly what I'm trying to do here.
Minister,